Okay, welcome. So, if you don't know, I am just a layperson that has an interest in lawsuits. So, I'm only here because these topics interest me. Um, the title was Can AI be sued for defamation? Well, the short answer is going to be yes, because people can be, or companies, entities, people can be sued for a number of reasons, but it's what happens with the judgment of that. And so I have the actual summary judgment by the federal judge. And then I also will be showing y'all the article that breaks down what this summary judgment says so we can kind of make sure we're on the same page. So this one, I only got to read a couple pages before I got this to y'all, but this is an individual, Mark Walters, that sued OpenAI ChatGPT, and it's because he was mentioned in something he actually wasn't a part of. And so we'll start there. We'll go through it together, and hopefully this doesn't freeze because my PDF was freezing earlier. Which I'm like, it's PDF. Why are you freezing? But this is Mark Walters, plaintiff versus OpenAI LLC, defendant. This is the order granting summary judgment in favor of defendant OpenAI LLC. This matter coming before the court for ruling on the motion of defendant OpenAI LLC for summary judgment pursuant to OCGA 91156, due notice given, and the court having received and reviewed all pleadings filed by all parties and the entire record available to this court, and having heard oral argument, it is hereby ordered that summary judgment is granted in full to OpenAI. Okay, here's the background. Although plaintiff Mark Walters contends he is not a public figure in that he does not regularly appear in the media on major television networks, having been interviewed only once on Fox Business and once by the local NBC affiliate in New York, it is undisputed fact that he is a nationally prominent radio show host who hosts two nationally syndicated radio programs and identifies himself as the loudest voice in America fighting for gun rights. Okay. It says he can be heard 6 days a week for more than 10 hours per week on radio stations and streaming services. Walters estimated that 1.2 million listeners tune in to each 15-minute segment of his radio programs. He is also an author of books and articles on Second Amendment rights and a media commentator. He serves as a member of the board of directors of the Citizens Committee for the Right to Keep and Bear Arms and as the East Coast media spokesperson for the Second Amendment Foundation. Defendant OpenAI is an artificial intelligence developer that created the AI chatbot ChatGPT. ChatGPT is a tool that allows users to access a large language model or LLM that is trained on vast amounts of data to generate new text in response to a user's prompt by predicting what words will come next. Due to their generative nature, all of the major LLMs that are currently available to the public are capable of generating information contradicting the source material, sometimes referred to as hallucinations. I had never heard that before. On May 3rd, 2023, a journalist named Frederick, I'm going to pronounce his name Real, used ChatGPT. Real is the editor of AmmoLand.com, a news and advocacy site related to Second Amendment rights, and in 2023, he was a member of the board of directors of the SAF. That day, the SAF filed a lawsuit against the Attorney General of the state of Washington in Washington Federal District Court, captioned SAF versus Ferguson. The Ferguson complaint alleged that the Washington Attorney General had singled out the Second Amendment Foundation for invasive and expensive harassment because of its political beliefs and activities, including its position on gun control. Real received a press release from the SAF about the Ferguson complaint and a link to a publicly available copy of the complaint. On May 3rd, Real was contemplating writing an article for AmmoLand.com about the Ferguson complaint and asked ChatGPT to summarize it. Real had past experience using ChatGPT and was familiar with past occasions on which the program had provided flat out fictional responses to some of his questions. On May 3rd, Real accepted ChatGPT's terms of use governing his interaction with ChatGPT, which specified, among other things, Given the probabilistic nature of machine learning, use of ChatGPT may in some situations result in incorrect output that does not accurately reflect real people, places, or facts. You should evaluate the accuracy of any output as appropriate for your use case, including by using human review of the output. Real also encountered multiple other disclaimers during his use of ChatGPT, including a warning that the system may occasionally generate incorrect or misleading information, and an on screen disclaimer visible through Real's interaction with ChatGPT, warning that ChatGPT may produce inaccurate information about people, places, or facts. Real pasted sections of the Ferguson complaint into ChatGPT and asked it to summarize those sections, which it did accurately. Real then provided an internet link or URL to the complaint to ChatGPT and asked it to summarize the information available at the link. ChatGPT responded that it did not have access to the internet and cannot read or retrieve any documents. Real provided the same URL again. This time, ChatGPT provided a different, inaccurate summary of the Ferguson complaint, saying that it involved allegations of embezzlement by an unidentified SAF treasurer and chief financial officer. Real again provided the URL and asked ChatGPT if it could read it. ChatGPT responded yes, and again said the complaint involved allegations of embezzlement. This time, it said that the accused embezzler was an individual named Mark Walters, and Mark Walters is the plaintiff on this defamation lawsuit, who ChatGPT said was the treasurer and chief financial officer of the SAF. After doing other research online, Real asked ChatGPT to identify any news reports about the litigation it was describing. ChatGPT responded that it had a knowledge cutoff date of September 2021, well before the Ferguson complaint was filed, and told Real that it did not have any information on news reports about this specific case. And then they're saying at row 26 and at row 23, ChatGPT noting it did not have access to real-time news or media updates. Real testified that within about an hour and a half, he had established that whatever Real was seeing in ChatGPT's output was not true. Then it says Walters has testified that he incurred no damages from ChatGPT's false claim that he was accused of embezzling funds from the SAF and is not claiming here that he has been harmed. Walters also testified that he did not ask OpenAI to correct or retract the false claim that he was accused of embezzling funds from the SAF. All right, so here's the legal standard. Summary judgment is appropriate if the moving party demonstrates that there is no genuine issue as to any material fact and that the moving party is entitled to a judgment as a matter of law. A defendant can meet this requirement by presenting evidence negating an essential element of the plaintiff's claims or establishing from the record an absence of evidence to support such claims. Therefore, a defendant who will not bear the burden of proof at trial need not affirmatively disprove the non-moving party's case, but may point out by reference to the evidence in the record that there is an absence of evidence to support any essential element of the non-moving party's case. Moreover, where a defendant moving for summary judgment discharges this burden, the non-moving party cannot rest on its pleadings, but rather must point to specific evidence giving rise to a triable issue. Summary judgment procedures have been determined to be particularly appropriate in defamation actions where the First Amendment is applicable. So here's the discussion. Walter's claim fails on this record, and summary judgment will be entered in favor of OpenAI for 3 independent reasons. The challenged output does not communicate defamatory meaning as a matter of law. OpenAI argues that the challenged ChatGPT output does not communicate defamatory meaning as a matter of law. The court agrees with OpenAI. A defamation plaintiff must establish that the statements at issue could be reasonably understood as describing actual facts about the plaintiff or actual events in which he participated. I'm going down from their references. This objective test is not whether some actual readers were misled, but whether the hypothetical reasonable reader could be after time for reflection. So they're saying it's not even, so that's how the salacious things can probably come out, like the National Enquirer and things like that, how they would put some crazy stuff out there. But if a reasonable reader is like, okay, I read it, it was crazy, but I don't believe that. After time of reflection, that might be how they get protected from defamation lawsuits from, when they were really, really popular. And then of course now you have a lot of blogs and other things that are put out there. And then it says disclaimer or cautionary language weighs in the determination of whether this objective reasonable reader standard is met. I'm going down. Well, actually, I'll go ahead and cite these. Control Core versus Genesis 1 Computer Corporation. It says courts evaluating defamatory meaning must give weight to cautionary terms used by the person publishing the statement. So, disclaimer that is replete with hedging language such as could, we do not know, we believe, and etc., meant that a statement did not communicate a defamatory meaning. And of course, the very popular allegedly that we use a lot now. Under the circumstances present here, a reasonable reader in Real's position could not have concluded that the challenged ChatGPT output communicated actual facts. In this specific interaction, ChatGPT warned Real that it could not access the internet or access the link to the Ferguson complaint that Real provided to it, and that it did not have information about the period of time in which the complaint was filed, which was after its knowledge cutoff date. Before Real provided the link to the complaint, ChatGPT accurately summarized the Ferguson complaint based on text Real inputted. After Real provided the link and after ChatGPT initially warned that it could not access the link, ChatGPT provided a completely different and inaccurate summary. Additionally, ChatGPT users, including Real, were repeatedly warned, including in the terms of use that govern interactions with ChatGPT, that ChatGPT can and does sometimes provide factually inaccurate information. A reasonable user like Real, especially a repeat user in my opinion, who was aware from past experience that ChatGPT can and does provide flat out fictional responses, and who had received the repeated disclaimers warning that mistaken output was a real possibility, would not have believed the output was stating actual facts about Walters without attempting to verify it. Hold on. I guess that's just where it stops, without attempting to verify it. Okay. As OpenAI's expert Dr. White explained, whose testimony Walters did not rebut, the output obtained by Mr. Frederick Real on May 3rd, 2023, contained clear warnings, contradictions, and other red flags that it was not factual. And I'm going to say definitely a red flag would be if your summary is totally different from your first summary, or you just told me you couldn't even do a summary and now you have a summary, you definitely want to go back and check it. I have some thoughts, but I'll keep it at the end of the lawsuit. In addition, Mr. Real's own prompt engineering techniques and choice to ignore ChatGPT's warnings about its limitations contributed to the non-factual output. The undisputed record of Real's interactions make that conclusion unavoidable. These multiple indicia, ChatGPT's warnings, refusals, inconsistent responses, and the other behaviors summarized above objectively establish to any reasonable reader that the challenged GPT output was not stating actual facts. Hold on. That is especially true here, where Real had already received a press release about the Ferguson complaint and had access to a copy of the complaint that allowed him immediately to verify that the output was not true. Real admitted that within about an hour and a half, he had established that whatever Real was seeing in ChatGPT's output was not true. As Real testified, he understood that the machine completely fantasized this. Crazy. Under these circumstances, as a matter of law, no reasonable reader in Real's position, after time for reflection, could have interpreted the output as communicating actual facts. Indeed, Real himself, After time for reflection, within about an hour and a half, had confirmed the output did not contain actual facts. Because no reasonable reader could have understood the challenged ChatGPT output as commuting actual facts, it is not defamatory as a matter of law. Okay, I'm going down. Separately, it is undisputed that Real did not actually believe that the Ferguson complaint accused Walters of embezzling from the SAF. If the individual who reads a challenged statement does not subjectively believe it to be factual, then the statement is not defamatory as a matter of law. And it says Sigmund versus Womack, quotation marks and citation omitted. Walters alleges here that he was defamed when ChatGPT told Real that the SAF versus Ferguson complaint alleged that Walters, the treasurer and chief financial officer of SAF, had embezzled funds from the SAF. There is no genuine dispute that Real knew ChatGPT's output was not factual. He knew Walters was not and had never been the treasurer or chief financial officer of the SAF, an organization for which Real served on the board of directors. He already understood in a high level way what the Ferguson complaint alleged based on his review of the SAF's press release about it. Real had access to a copy of the complaint and could immediately review it to verify what ChatGPT said. He testified that when ChatGPT told him the Ferguson complaint involved allegations of embezzlement, he knew that response was the wrong information, not accurate, and not what the document is about. He testified that he was skeptical of the story ChatGPT was telling him about Walters being accused of financial misconduct. Also, he confirmed with certainty within about an hour and a half that whatever he was seeing in ChatGPT's output was not true. Instead, he knew the machine completely fantasized the output and that the output was crazy. Because Real did not believe the output, it did not communicate defamatory meaning as a matter of law. The court finds that the challenged output does not communicate defamatory meaning as a matter of law. This alone is sufficient to require summary judgment in favor of OpenAI. So before we go to the number 2 reason, what I'm gathering from it is Real was the writer of the article, the author of the article. He's using ChatGPT. He's familiar with ChatGPT. He had to acknowledge the disclaimers of ChatGPT. He also had inside knowledge already about Walter's role in the SAF. So when he saw the completely inaccurate output, he already knew that ChatGPT, one, would not state facts all the time. It will make things up. And two, he personally knew Walters did not hold those positions. So it for him to have the reflection and to go back, he would know that this is not true. Therefore, this is going back to OpenAI / ChatGPT's defense. They're saying this is not defamatory because he had time to reasonably reflect and know those statements could not be true and weren't being even made to look like they were true, and so therefore it is not defamation. That's how I'm taking it. Again, I take this as users have to be responsible for what they use it for, and we'll look at and the article kind of references it about attorneys not going back and checking case law that's cited, and it was talking about how ChatGPT will make up fake case law. Like, you have to go back and check your things yourself. Okay, number 2, Walters cannot show fault under either the negligence or the actual malice standard. OpenAI also argues that Walters cannot meet his burden of establishing fault. The court agrees with OpenAI on this issue as well. Under Georgia law, a defamation plaintiff must demonstrate at minimum that the defendant published the allegedly defamatory statements with at least ordinary negligence. Even if the actual malice standard did not apply here, and it does, for the reasons set out below at Section 2B, Walters has not identified evidence on which the jury could rely to find that OpenAI published the allegedly defamatory statements with at least ordinary negligence. And just to keep it on point, Walters is the plaintiff in this federal lawsuit, and OpenAI ChatGPT is the defendant. But Real apparently has played a very key role in putting out the article that ChatGPT produced, or he He used ChatGPT to write an article, and it had just lies in there. And so that's why real keeps getting mentioned, but this is Walters versus OpenAI. It says where a plaintiff must prove ordinary negligence, the plaintiff must also identify an applicable standard of care and establish that the defendant did not meet it. Walters has done neither. Walters' opposition brief on this point consists of a single sentence. OpenAI has not argued that it was not at least negligent, but in any event, the lack of negligence is a question for the jury and ordinarily cannot be decided by this court on summary judgment. Not only does that misstate the burden on a plaintiff as summary judgment, but also OpenAI did argue that Walters has not met the standard of ordinary negligence as a matter of law. And some of this, again, it'll be elaborated in the article that we're going to look at. The Court of Appeals has held that in a defamation case, the standard of conduct required of a publisher will be defined by reference to the procedures a reasonable publisher in its position would have employed prior to publishing an item such as the one at issue. A publisher will be held to the skill and experience normally exercised by members of its profession. Custom in the trade is relevant but not controlling. Walters has identified no evidence of what procedures a reasonable publisher in OpenAI's position would have employed based on the skill and experience normally exercised by members of its profession. Nor has Walters identified any evidence that OpenAI failed to meet this standard. And OpenAI has offered evidence from its expert, Dr. White, which Walters did not rebut or even address, demonstrating that OpenAI leads the AI industry in attempting to reduce and avoid mistaken output like the challenged output here. Specifically, OpenAI exercised reasonable care in designing and releasing ChatGPT based on both one, the industry-leading efforts OpenAI undertook to maximize alignment of ChatGPT's output to the user's intent and therefore reduce the likelihood of hallucination, and two, providing robust and recurrent warnings to users about the possibility of hallucinations in ChatGPT output. OpenAI has gone to great lengths to reduce hallucination in ChatGPT and the various LLMs that OpenAI has made available to users through ChatGPT. One way OpenAI has worked to maximize alignment of ChatGPT's output to the user's intent is to train its LLMs on enormous amounts of data and then fine-tune the LLM with human feedback, a process referred to as reinforcement learning from human feedback. OpenAI has also taken extensive steps to warn users that ChatGPT may generate inaccurate outputs at times, which further negates any possibility that Walters could show OpenAI was negligent. In the face of this undisputed evidence, counsel for Walters asserted at oral argument that OpenAI was negligent because a prudent man would take care not to unleash a system on the public that makes up random false statements about others. I don't think this court can determine as a matter of law that not doing something as simple as just not turning the system on, yet was, something that a prudent man would not do. In other words, Walters' counsel argued that because ChatGPT is capable of producing mistaken output, OpenAI was at fault simply by operating ChatGPT at all, without regard either to the procedures a reasonable publisher in OpenAI's position would have employed or to the skill and experience normally exercised by members of its profession. The court is not persuaded by plaintiff's argument. Walters has not identified any case holding that a publisher is negligent as a matter of defamation law merely because it knows it can make a mistake and for good reason. Such a rule would impose a standard of strict liability, not negligence, because it would hold OpenAI liable for injury without any reference to a reasonable degree of skill and care as measured against a certain community. The U.S. Supreme Court and the Georgia Supreme Court have clearly held that a defamation plaintiff must prove that the defendant acted with at least ordinary negligence and may not hold the defendant liable without fault. And based on the testimony of OpenAI's expert Dr. White, which Walters did not refute, due to their generative nature, all of the major LLMs that are currently available to the public are capable of hallucinating. In other words, based on the undisputed facts, Walter's argument would mean that an AI developer like OpenAI could not operate a large language model like ChatGPT at all, no matter the care it took to reduce the risk of errors, without facing liability for any mistaken output the model generated. That is not a negligence standard, and both Georgia law and federal constitutional law prohibit applying it to Walter's defamation claim. In sum, Walters has offered no evidence, no deposition testimony, no documents, and no expert report showing that OpenAI was negligent. Summary judgment is therefore warranted in OpenAI's favor on this separate ground as well. Walters is a public figure who must but cannot establish actual malice. Even if Walters could establish that OpenAI acted with at least ordinary negligence, summary judgment should still issue to OpenAI because Walters is a public figure and must but cannot establish actual malice to hold OpenAI liable. Okay, so it can't just be that misinformation was put out on a public figure. You have to also then establish it was done maliciously. And ChatGPT, the company OpenAI, no, for him, maybe for somebody, but for him, they would not have had malice. Now, the person looking up things on him, maybe the author Real, and which is why I'm wondering, is Walters going to turn around and sue Real for defamation? Because Real is the one that used the information that ChatGPT put out there to write something bad on Walters that he could have easily disproven because he knew Walters was not CFO and all that other stuff. I'm wondering because this is just removing OpenAI from being a defendant in this, but Real, he still did write that stuff or publish that stuff knowing it was inaccurate. So, but yeah, so Real might have had the malice, but ChatGPT did not have the malice. Walters is a public figure. The U.S. Supreme Court has held that defamation plaintiffs will qualify as public figures if the plaintiffs have significantly greater access to the channels of effective communication and a more realistic opportunity to counteract false statements than private individuals normally enjoy, and have assumed roles of a special prominence in the affairs of society, and voluntarily expose themselves to increased risk of defamatory falsehood. Whether a defamation plaintiff qualifies as a public figure is a question of law for the court to decide. In evaluating whether a plaintiff qualifies as a public figure, courts consider previous coverage of the plaintiff in the press, the voluntariness of the plaintiff's prominence, and the availability of self-help through press coverage of responses. Walters qualifies as a public figure given his prominence as a radio host and commentator on constitutional rights and the large audience he has built for his radio program. He admits that his radio program attracts 1.2 million users for each 15-minute segment and calls himself the loudest voice in America fighting for gun rights. Like the plaintiff in Williams versus Trust Company of Georgia, Walters is a public figure because he has received widespread publicity for his civil rights activities, has his own radio program, took his cause to the people to ask the public support, and is outspoken on subjects of public interest. Going down. Additionally, Walters qualifies as a public figure because he has a more realistic opportunity to counteract false statements than private individuals normally enjoy. He is a radio host with a large audience, and he has actually used his radio platform to address the false ChatGPT statements at issue here. As the Court of Appeals has observed, figures as widely varying as a college athletic director, a basketball coach, a professional boxer, and a professional baseball player, among others, have all been held to be public figures. Walter is a limited purpose public figure. Notwithstanding the above analysis, at a minimum, Walters qualifies as a limited purpose public figure here because these statements are plainly germane to Walters' conceded involvement in the public controversies that are related to ChatGPT output at issue here. The challenge ChatGPT output relates to the public controversy and national debate over the Second Amendment and gun rights. ChatGPT provided the output in response to prompts Real submitted regarding a lawsuit filed by the Second Amendment Foundation in Washington Federal District Court alleging unconstitutional retaliation against its efforts to advocate for Second Amendment rights. And the output itself though false, described allegations that Walters, a prominent Second Amendment rights activist and media figure, had embezzled money from a Second Amendment rights advocacy organization for which he served as the East Coast media spokesperson. Given that undisputed context, the challenged output related to the public controversies regarding Second Amendment rights. Walters' counsel conceded at oral argument that Walters is involved in public controversies, including the Second Amendment debate and gun rights generally, and things like that. The undisputed facts establish the same. The challenged ChatGPT output is germane to those controversies. Anything which might touch on the controversy is relevant, and the publication is germane to a plaintiff's participation in a controversy if it might help the public decide how much credence should be given to the plaintiff. ChatGPT's challenged output describing false allegations that Walters had embezzled from a prominent Second Amendment rights advocacy organization is germane because it might affect how much credence the public gave Walters on Second Amendment issues. All this establishes that Walters is, at minimum, a limited purpose public figure here. Walters argues that the topic of the defamatory statements was Walters' alleged malfeasance regarding SAF's funds and related fraud. There is nothing in the record indicating that this was a public controversy. OpenAI points to nothing showing that there was public discussion, debate, and dissent about Walters' non-existent involvement in the non-existent controversy. Plaintiff's opposition brief at 9. In other words, Walters argues that the only controversies related to the challenged ChatGPT output are the literal words of the output itself. You know what this is actually bringing my brain to real fast? What's so crazy, okay, Walters is a Second Amendment advocate, right? If, unfortunately, someone was taken out with a weapon, right? With a gun. Someone in his family or something. They would not go after Smith and Wesson. They would go after the person that was wielding the Smith and Wesson. So I'm seeing this as you kind of have to go after the journalists that used the ChatGPT output and wrote those things about you versus the people that created ChatGPT. That's kind of how I'm seeing it, because I know a Second Amendment person will argue it's the person, not the weapon type thing. You know what I mean? So I find it crazy, because if you're saying just the fact of inventing ChatGPT is bad, then inventing a gun could technically just be bad because of the potential it has to do harm. So it's very interesting that that's his argument against ChatGPT. That's what my brain just went to just now. Now I have to find my spot. Let's see. Okay, the court is not persuaded by plaintiff's argument. Courts have regularly rejected attempts to define the relevant controversy so narrowly included in Jewell. There, the courts of appeals approved of the trial court's decision to reject the plaintiff's attempt to define the controversy too narrowly and instead to identify the broader question related to the challenge statement as the relevant controversy. By definition, defamation involves an allegation that a plaintiff did something which they did not actually do. If the controversy were drawn as the action which the plaintiff did not take, then the plaintiff would never be involved in the controversy. For that reason, the controversies related to the challenged ChatGPT output are the broader questions that provide the context for the output. Those relevant controversies are the same controversies for which, as Walters' counsel conceded, Walters is a public figure: the Second Amendment debate and gun rights generally, and things like that. Walters cannot meet the actual malice standard. Because Walters qualifies as a public figure, he must meet the actual malice standard, meaning he must prove by clear and convincing evidence that OpenAI either knew that the alleged defamatory statements were false or was aware of the likelihood it was circulating false information. In other words, Walters must prove OpenAI actually had a subjective awareness of probable falsity when the material was published. Unless the court finds on the basis of pretrial affidavits, depositions, or other documentary evidence that the plaintiff can prove actual malice in the sense, the court should grant summary judgment for the defendant. There is no genuine dispute that Walters has no evidence OpenAI acted with actual malice. As OpenAI's expert Dr. White explained, whose evidence Walters did not attempt to rebut, OpenAI has gone to great lengths to reduce hallucination in ChatGPT and the various LLMs that OpenAI has made available to users through ChatGPT. Furthermore, at all times that ChatGPT has been available to the public, OpenAI has included multiple warnings directly to ChatGPT users regarding the possibility that ChatGPT may generate factually inaccurate output. OpenAI's industry leading efforts to reduce errors of this kind and its extensive warnings to users that errors of this kind could occur negate any possibility that a jury could find OpenAI acted with actual malice here. Walter's two arguments that he has shown actual malice fails. First, he argues that OpenAI acted with actual malice because OpenAI told users that ChatGPT is a research tool. Plaintiff's opposition brief I'm sorry, that's just the thing. Plaintiff's opposition brief at 14. But this claim does not in any way relate to whether OpenAI subjectively knew that the challenged ChatGPT output was false at the time it was published, or recklessly disregarded the possibility that it might be false and published it anyway, which is what the actual malice standard requires. Walters presents no evidence that anyone at OpenAI had any way of knowing that the output Real received would probably be false. Only such evidence could meet Walters' burden of showing actual malice. Walters has identified none. Again, the undisputed evidence in the record establishes the opposite. OpenAI made substantial efforts, which OpenAI's expert in unrebutted testimony characterized as industry leading, to avoid errors of this kind and to warn users that such errors might occur and that users should evaluate output to identify any errors that might exist. So basically, all of this is put back on the responsibility of the end user of ChatGPT. OpenAI also provides what OpenAI's expert described as robust and recurrent warnings to users, cautioning them that errors might occur and advising users that they should evaluate output to identify any errors that might exist. All this, which OpenAI's expert testified demonstrated reasonable care on OpenAI's part, testimony that Walters did not address or refute, negates the possibility that OpenAI acted with actual malice here. Second, Walters appears to argue that OpenAI acted with actual malice because it is undisputed that OpenAI was aware that ChatGPT could make mistakes in providing output to users. The mere knowledge that a mistake was possible falls far short of the requisite clear and convincing evidence that OpenAI actually had a subjective awareness of probable falsity when ChatGPT published the specific challenged output itself. The undisputed evidence demonstrates that OpenAI warned users that errors could exist and that users, including Real himself, were aware that errors could occur. And it says again, Real was aware from past experience that ChatGPT could provide flat out fictional responses. Walters has not identified evidence on which the jury could rely to find that he has met the actual malice standard. Even if the actual malice standard did not apply here, Walters has identified no evidence on which a jury could rely to find that he had carried the burden of showing that OpenAI acted with at least ordinary negligence. The absence of evidence of fault is also an independent reason to grant summary judgment in OpenAI's favor. Walters cannot recover damages. Finally, OpenAI argues that there are no damages Walters could recover at trial. The court also agrees with OpenAI on this final issue. Walters conceded at his deposition that he did not incur actual damages and is not seeking actual damages here. That's interesting. Okay, it says all liable plaintiffs who intend to seek punitive damages must request a correction or retraction before filing their civil action against any person for publishing a false defamatory statement. This is actually what happened in the Meg Thee Stallion defamation case, on why the part where they awarded her, where the jury awarded her for defamation, but the judge said no, defamation cannot stick because there was not a request to retract the statement. Thank you, Linda. It says Walters conceded that he did not request that OpenAI correct or retract the challenged ChatGPT output. He is therefore prohibited by statute from obtaining punitive damages here. Walters Walters argues that a retraction or correction request would have been useless and meaningless, and that it is unclear what a retraction would look like or if one were possible. Those arguments are both speculative and irrelevant to whether Walters is eligible to seek punitive damages. The statute and the Georgia Supreme Court's Mathis decision are unambiguous. A plaintiff who does not request that a defendant correct or retract a challenge statement may not obtain punitive damages. Whether OpenAI could have satisfied that request is irrelevant. It says Walters cannot recover presumed or punitive damages under the First Amendment. Last, Walters argues that he is entitled to presumed damages because the defamation in this case was defamation per se, which requires no showing of actual damages. Plaintiff's opposition brief is 16. Walters is not entitled to recover presumed damages here. It is correct that where a statement is defamatory per se by imputing the commission of a crime to another, the law infers an injury to the reputation without proof of special damages. Such an injury falls within the category of general damages, those which the law presumes to flow from any tortious acts. As the U.S. Supreme Court has explained, the doctrine of presumed damages exists because those forms of defamation that are actionable per se are virtually certain to cause serious injury to reputation. But such injuries are extremely difficult to prove, so the law assumes that damage has occurred without requiring plaintiffs to prove it. However, as counsel for OpenAI argued at oral argument, the evidence can rebut the presumption of damages. It says, even if we assume that defendant published a statement that was defamatory per se, any presumption of damages was rebutted by the evidence showing no pecuniary or reputational harm. Going down. In Wilson versus Wilson, it said presumed damages were rebutted where plaintiff admitted that the only people who heard the challenge statement had not believed it and that he had suffered no adverse consequences at work. Okay. It says here, any presumption of damage to Walters has been rebutted by Walters' own admissions. Walters conceded that he is not claiming here that he has been harmed. That concession is consistent with the undisputed evidence. Real, the only person who received the challenged ChatGPT output, was always skeptical about ChatGPT's output, established after approximately an hour and a half that the output was not true and did not republish it. It is undisputed that Walters could not have sustained any injury of any kind, whether a quantifiable economic loss or any injury to the reputation that flowed from the challenged ChatGPT output. That did not read like a full sentence to me, but I'll keep going. Where the undisputed facts establish that no injury of any kind could have occurred, and where the plaintiff admits under oath that he is not claiming he was harmed, no presumed damages are appropriate. Such damages would constitute compensation for injuries that do not exist. Regardless, even if presumed damages were available on this record, they are not Walters. Regardless, even if presumed damages were available on this record, they are not. Walters is also foreclosed from obtaining presumed damages here under the First Amendment to the U.S. Constitution. The same rule independently prohibits Walters from recovering punitive damages, even if punitive damages were not statutorily barred under OGCA 5152. As the Georgia Supreme Court has held, even a private figure plaintiff is required to prove actual malice in order to recover presumed or punitive damages if the defamatory statement was about a matter of public concern. The private defamation plaintiff who establishes liability under a less demanding standard than that stated by New York Times may recover only such damages as are sufficient to compensate him for actual injury. The challenge statements here involve a matter of public concern. They were elicited by Real, a reporter who was considering writing an article about a publicly filed lawsuit brought by a constitutional rights advocacy organization against a state attorney general relating to freedom of speech. Because they involve a matter of public concern, Walters cannot recover presumed damages or punitive damages unless he can meet the actual malice standard. And for the reasons set out above in Section 2A of this order, he cannot do so. Walters argues that the challenged statements do not qualify as a matter of public concern because they were wholly in the interest of the speaker and the specific audience, relying on the U.S. Supreme Court's decision in Dun and Bradstreet versus Green Moss Buildings, Inc. In Dun and Bradstreet, the plaintiff sued over a credit report provided to 5 subscribers who were contractually forbidden from sharing it with others that falsely reported the plaintiff had filed for bankruptcy, a matter of purely private concern. The challenged output here was not, like the credit report in Dun and Bradstreet, about the private business concerns of a company and its creditors, nor was it provided under a requirement of confidentiality. Real, a journalist, was using ChatGPT as part of preparing a contemplated article for public distribution about the Ferguson complaint and the issues of public importance that were involved in that lawsuit, and he was permitted to share output he received from ChatGPT. Unlike the credit report in Dun and Bradstreet, these challenge statements involve a matter of public concern. Therefore, Walters, regardless of whether he qualifies as a public figure or a private figure, cannot obtain either presumed or punitive damages unless he can show actual malice, which, for the reasons set out above, Walters cannot do. Walters cannot recover any damages, actual, punitive, or presumed, as a matter of law. This, too, is an independently sufficient basis to grant summary judgment in favor of OpenAI. For the reasons stated above, the court hereby grants defendant OpenAI's motion for summary judgment. The court enters judgment in favor of defendant OpenAI and against plaintiff Walters and directs defendant OpenAI to complete the civil case disposition form. Okay, now this article is going to help us make all the sense of the stuff that we were reading. Okay, it says, see, it's crazy that they got on Twitter creators about algorithm codes, but whoever created OpenAI, whatever this program, can be made to tweak the code. No, they're saying that they are. That's their whole argument. Their expert is saying that that is what they continue to do, is they build this reinforcement loop. They have it generate stuff, then they have humans review it to go back and say, well, this wouldn't make sense or this is not correct. So they're saying now this is what they're saying publicly. It's still, AI is crazy. I'm not saying it's not, but they are saying and they are showing that they're trying to prove that or improve that feedback loop so it reduces each time. It may not give back the best information, but it's also warning you can't go relying on this, attorneys, as facts all the time. Like you have to research this. It's just putting stuff out there. Like it's still learning and everything. So no, they are holding themselves accountable. So they're not being, as they put it in one section, it says something negligent. They're not being negligent like that. Not shooting the messenger. Okay, let's look at this article real fast, because this article, written by an attorney, helps us lay people really make sure we understand what's going on. So let's look at this article, and then I'll be done. Let me see. Take this off. All right. Okay. So it says AI defamation suit tests anti-slap shields and speakers' rights. So it says judges have increasingly reprimanded attorneys for citing fictional cases in briefs generated by I'm about to make this a little bit bigger. In briefs generated by AI. In these situations, everyone agrees that attorneys should be held accountable, but but what happens when AI technology generates false content that defames you or your business? How do we determine who should be accountable then? This is the novel question that courts are grappling with as defamation cases are starting to pop up around the country over AI generated content. And he says none of these cases have been filed in California yet. Defamation laws vary from state to state, but the basic elements are generally the same. A publication that is false, defamatory, unprivileged, and has a natural tendency to injure or cause special damage. A plaintiff must also establish the requisite level of fault, whether it be negligence as a private figure or actual malice as a public figure. And we saw for Walters, it was actual malice because the court deemed him to be a public figure, which I'm like, how do you even argue that you're not a public figure, but you have a whole radio show and you have 1.5 million listeners? Like, come on. But it says actual malice requires clear and convincing evidence that the defendant made the statements with knowledge of their falsity or reckless disregard for the truth. And here we go is the case we just read, or the summary judgment we just read over. Walters versus OpenAI. Um, Demonstrates how one court applied these traditional defamation principles to modern AI communication technology. In May 2025, a Georgia court granted summary judgment to OpenAI, creator of ChatGPT, in a defamation lawsuit by radio host Mark Walters. Walters sued when ChatGPT provided a summary to a journalist falsely stating Walters was being accused of embezzlement in a lawsuit he had no involvement in. The journalist, however, knew that ChatGPT could provide fictional responses and quickly determined that the summary was false. The court made several key findings: that no reasonable reader could have concluded that ChatGPT was communicating actual facts about Walters, given ChatGPT's warnings about potential inaccuracies, inconsistent responses, and the journalist's doubt and quick determination that the summary did not contain actual facts. Also, Walters, as a public figure, could not prove actual malice or refute OpenAI's evidence of its industry leading efforts to reduce AI hallucinations, aka fabricated facts, and warnings about potential inaccuracies. These efforts and warnings showed OpenAI was not negligent either. And three, Walters had no recoverable damages because he conceded he was not harmed. This decision, while limited to the unique facts of that case, suggests that AI developers may not be liable for defamation based on isolated inaccuracies when it has made efforts to reduce potential inaccuracies and warns users about them. This attorney says it will be interesting to see how other courts deal with these issues, including in LTL LED, DBA Wolf River Electric versus Google, a defamation case filed in March 2025 in Minnesota. Wolf River sued Google for publishing search results falsely claiming that it had been sued for deceptive sales practices, among other things. Wolf River is claiming significant damages, including canceled contracts in the realm of $110 to $210 million. Wolf River is in its initial stages, with plaintiffs seeking to remand the case to state court after Google removed it to federal court. This detail, however, raises a natural procedural question for defamation litigators, which applies to the Walters case as well. Why did the defendants not file special motions to strike in these cases? These motions, known as anti-SLAPP motions, are routine in defamation litigation. SLAPP is an acronym for Strategic Lawsuit Against Public Participation. Anti-SLAPP laws usually allow defendants to file an early special motion to strike to dismiss entire complaints or specific causes of action that they claim chill their exercise of constitutionally protected rights. Since most anti-SLAPP statutes apply to speech made in connection with an issue of public interest, defamation defendants almost always claim that they were exercising their free speech rights. More stringent anti-SLAPP laws state state discovery, award prevailing defendants their attorney's fees and costs, and grant losing defendants the right to an immediate appeal. Both Georgia and Minnesota have strict anti-SLAPP laws. I'm skipping over the references. Let me see. Walters and Wolf River filed complaints in their respective state courts, but rather than seek early dismissals under the relevant anti-SLAPP laws, defendants in both cases opted to remove them to federal court, where the anti-SLAPP laws either do not apply or are uncertain to apply. The federal circuits are split on whether state anti-SLAPP statutes apply in federal court. The 11th Circuit, where Georgia is located, does not apply state anti-SLAPP laws. The 8th Circuit, located in Missouri, has not decided the issue, but the U.S. District Court, District of Minnesota, held Minnesota's prior anti-SLAPP statute did not apply. The statute was later found unconstitutional in Mobile Diagnostic Imaging, Inc. versus Hooten. It is undecided whether Minnesota's new anti-SLAPP law, effective May 2024, will apply in federal court, though Unity Healthcare suggests it will not. In our experience, defendants generally prefer federal courts, which tend to be less favorable to state law defamation claims, but they also routinely take advantage of state law anti-SLAPP statutes. It therefore stood out to us, this is the attorneys, I believe, writing this, that the Walters and Wolf River defendants did not file anti-SLAPP motions. While there may be special nuances to the particular anti-SLAPP statutes that affect their applicability in those cases, this also presents broader questions regarding whether whether and how the AI generated content triggers constitutional free speech protections for purposes of anti SLAPP laws in general. Either way, we can expect these anti SLAPP issues to come up in future cases and are curious to see how courts will address them. Okay. Woo, I appreciate these attorneys. Hey, Ashley. Thank you, Miss Queen Liz. I appreciate you sticking in there with me. And yeah, these topics interest me. The article to me really, really breaks it down, but I did want to actually see it for myself, see how I was understanding the judgment before I then went to the article to see how I broke it down. I possibly will be a future law student one day. I just want to see, but this was fun to me. These are fun to me. Hey, Cece. So yeah, so let me know what y'all think about the OpenAI's defense. The federal judge decided, yeah, there was no defamation case. I was surprised that Walters didn't claim any damage, and I guess he went after the big fish. But yeah, your defense that the tool never should exist at all, that's not gonna go because the federal government is using its own form of AI tools and ChatGPT and Gemini anyway. So that's. I just don't know if that would help you that it just shouldn't exist. But please be responsible using ChatGPT. um, as someone that needs to organize their thoughts, there are many uses for it. It doesn't have to be used for anything bad. It is, and one of the things that I do when I'm looking at articles that interest me and I'm trying to get my thoughts together, I do tell it, do not make any inferences from the article. That is one thing. I don't need to know what you thought it meant. I just need some bullet points because I'm looking at a lot of articles, and y'all know I love my body cams and stuff like that. So I have, and I have to tell you, it does warn you a lot. This may not be accurate. You have to go back. I always go back. I'm always reading the articles for myself, but in organization assistance, I am somebody that loves to use it to help me organize my thoughts and things like that. And so I can pick out, I can pick out what I want to continue with and what I'm like, you know what, that one's not the best for me. I don't want to cover this one and stuff like that. So if you use it like I don't even want to say a calculator, but like a binder with many colorful tabs that helps you kind of organize some things, but you have to go back and look at your things yourself. And as you can see, apparently a lot of people are lazy because the attorneys were how it first was making headlines to me. When those attorneys kept getting in trouble for fake case law being cited, I was like, what are y'all doing? Y'all, if anybody should know, don't do this. Do not do this. I saw a video of the main creator of AI stating how it can be used dangerously. He seems to have remorse. Yeah, I mean, any tool that can spread widely, um, it's a lot of things that it can be used for harm. It just can. So I'm not surprised that he regrets it. It's just like when I watched the thing on Netflix where the people that kind of invented or helped build up, was it Twitter and Instagram? Probably Instagram, most of anything. They are the hardest on letting their kids or not letting their kids use social media because they know how harmful it can be. So yes, everything has a potential for great harm. And unfortunately, there's a lot of propaganda things that are put out there and made to look real, and it's not real. It's a lot of harm it can do. So I'm not even saying you should use it. I'm just saying be cautious and understand it can put out false information, and you need to be doing your own due diligence if you're using it. Um, for someone that I was telling my members, I'm actually going to eventually go see a doctor and find out if I have ADHD. Like for someone that I think I have, I don't know if I do, but I know I have some issues. It helps me really change the storm of my thoughts to something organized that I can move forward and not just have analysis paralysis and or just, it's just some things. So I am using it for what I like and the benefits I see it in. And I totally get if some people don't ever want to pick it up. I look, it's to each their own on their decisions. Just like if someone's like, I don't want to get TikTok because it's a time waster. You doom scroll, you lose track of time. I get it. I like TikTok because I find, in fact, I'm about to use TikTok to help me learn something new. I'll let y'all know about that later as I learn it. But yeah, it can be good and bad. Oh, you did? Okay, I'll be looking. I don't respond to every video, but at least one that you send me, I'll always be like, thank you, so I saw something. So thank you. I appreciate that. Yeah, it's just good rounding up a lot of stuff. But like it told him, I can't read a link. So why are you still trying to make it read a link? Let's see. I think I do, but I'll roll with it at least to some degree. On ChatGPT, it says you should still check the information because some things may not be accurate. And that was a huge part of how this lawsuit against ChatGPT was basically they were given their summary judgment in their favor because they tell the user you it's not most it's not it could not be accurate. It's very possible this information will not be accurate. You cannot just take this like fact like this. So yeah, that was the bulk of what they were trying to say and how they were working on it. But overall, they know it's not gonna be accurate. And they make the end user know that. So that's on the person at the end of the day. But yeah, use everything responsibly. It's like alcohol. Drink responsibly. Like everything. Don't just be careful. All right, y'all. But thank you. Y'all hung in here with me. I'm gonna go ahead and get ready for my night because I gotta go to work in the morning. Boo. But I definitely appreciate this. You don't know because this is more of the it can be a drier topic, but it interests me. And so when I see y'all come in for these type of little topics, oh my gosh, I'm on cloud nine. But all right, y'all. Talk to you later. Bye.